Actus non facit reum nisi mens et rea. This is a Latin expression which generally means an act does not constitute a crime unless there is a guilty mind. Let us now translate the Latin words into English for our better understanding. Actus means act. Non facit means he does not do. Reum means guilty. Nisi means except or unless. Mens et rea means let the mind be guilty. Then in this expression there are three parts. 1. Actus non facit reum means the act does not make him guilty. 2. Nisi means unless, and mens et rea means the mind be guilty. So without the guilty mind or criminal intention, an act done is not a crime. Say you have hit a ball towards the boundary to score a 6, but the ball hit the fielder's head and he died. There is no intention or criminal mind to kill the fielder, so there is no crime in the death of the fielder. Similarly, one have a guilty mind but had not acted on it, so there is no commission of offense, so there is no crime. To constitute a crime, two essential elements need to be present. 1. Guilty mind or criminal intention, and 2. Action need to be taken on the basis of the intention. Mens rea have to be present in the form of knowledge, purpose, recklessness and negligence. In common law, an act is not culpable unless the mind is guilty. An act is done without the criminal intent is not liable under the criminal law. So, in every crime, there are two aspects. One is physical aspect and 2 is mental aspect. The object behind the maxim is to differentiate between the intentional and unintentional crime in order to measure the quantum of punishment. The maxim was found in the writing of Lord Edward Coke of England. The maxim had been discussed in the Indian Penal Code of 1860. In firstly, while discussing what constitutes an offence, and secondly, in the chapter 5, while discussing the general exceptions. Further, in the section 14 of the Indian Evidence Act, the maxim finds its place while discuss the intention as an element to the act. There are some exceptions to this maxim, which means and include where requirement of intention is not essential. 1. Ignorance of law. 2. Strict liability. 3. Insanity. 4. Vicarious liability. 5. Public nuisance. 6. Petty offence. Some of the landmark judgment pronounced by the Indian courts in the light of this maxim. 1. C.K. Jafar Sharif versus CBI, Supreme Court, 2012. Ranjit D. Udesi versus State of Maharashtra, Supreme Court, 1964. 3. Hari Singh Gond versus State of Madhya Pradesh, Supreme Court, 2008. 4. Ram Bahadur Thapa versus State of Madhya Pradesh High Court, 2021. R. Balakrishna Pillai versus State of Kerala, Supreme Court, 1995. The maxim is the integral part of the criminal justice system, where mind or criminal intention play an important role in judging the quantum of the sentence. The onus is shouldered on the prosecution to coincide the mens rea and actus reus to prove the crime.